we're going to jump right in. This is the Bates International Group, and this is the Roundtable. We do this every single month at 6 o'clock on the first Thursday of the month. So it's always the same link, the same time. So we're really excited that we get to have Jack Carter from the title company here, who is gonna, tell us a bit about, yourself and your business and all the things that you do. And one thing I would like to say is, there's going to be some websites that are shared. If you don't get a chance to jot it down, if you refer to our YouTube channel, we'll make sure that, we make it clear and link those. And so Jack, without further ado, I won't take up any of your time. Why don't you just tell us a little bit about the title company and what you guys do?
Well, thank you very much for the invitation today. I really appreciate it. I'm excited to be with your group today. I hope that I get some questions along the way, because this is more fun if it's interactive. And I should throw this caveat out there. Because it's 6 p.m., I'm doing this from home. So if you hear any background noise, that is my 2- and 4-year-old who I asked to be quiet, but because they're 2 and 4, they're unpredictable. So hopefully they'll let us finish this without showing up in my room here. So let me tell you a little bit about me and the title company, just by way of introduction. I've been in the real estate business since I finished college in 2001. I spent a number of years in the mortgage business. I went to law school starting in 2007, finished law school, and managed a small title company up in Ellicott City for a number of years before in 2018, I resigned from my job on the very same day that my first son was born. My wife was supportive of this. It was pre-planned in advance, but yeah, I resigned from my last job the day my son was born. We started the title company just a few weeks after that, and we've been running ever since. So the title company's been up and running for 4 years now, going on 5. January 1st will be 5 years, and we handle real estate transactions. As far as lawyering goes, I stay in a very narrow lane. I never go into court. I don't sue people. I don't represent people. All we do is close real estate transactions. And the 3 that we handle are typically residential real estate purchases, residential real estate refinances, and quitclaim deeds. Quitclaim deeds are transfers of ownership that don't involve money. And it's usually family members being added or removed for whatever reason. There's been a change in circumstance. Maybe somebody got married, maybe somebody got divorced. There are as many different scenarios for quitclaim deeds as there are families and people in the world. So just about any scenario you can imagine, we can update the title to the land records. When it comes to title companies in general, not just the one that I own, which has the very generic name of the title company, but when people talk about the title company in general, there are, broadly speaking, 2 things that the title company will do in a transaction. First and foremost, we handle the money. Unlike most purchase transactions where the buyer just simply hands the money to the seller and the seller hands the goods or the services to the buyer, real estate involves a third party. So we are an independent third party that holds money in escrow. We collect all the money from the buyer and from their mortgage company, and we disperse the money out after the transaction. So we pay all the taxes, we pay all the seller's mortgages off, we give the proceeds to the seller, we pay the commissions to the real estate agents, we keep a little bit of money for ourselves, and at the end of the day, there should be no money left in the escrow account because every penny was used to pay everybody in the transaction. So that's the first thing we do, is we handle the money in the transaction. The second thing we do is we record the transaction into the land records. And generally speaking, in a purchase, that would be 2 documents. That would be your deed, which is the document that the seller signs that transfers legal ownership over to the buyer, and the mortgage, which the buyer signs to the bank and which creates the lien on the property that the buyer used to purchase the property. So broadly speaking, those are the 2 things that any real estate title company will do in a purchase transaction. They'll be the third party that handles the funds, sort of a clearinghouse for all the money in the transaction. And also we're responsible for updating the land records so that the county and the general public knows that there was a sale and know who owns the property now. And what I wanted to talk about today was going into those things in a little bit more depth, and specifically talking about deeds and title. And what is the difference between the 2? Because oftentimes I hear realtors using those terms interchangeably. And while often that's fine for casual speak, they actually mean two very different things. Title, when we talk about title in the real estate industry, is an abstract concept. It's the concept of ownership. Who owns the property right now? Who's on title to the property? The deed is a little different from that in that the deed is the document, and it can be a hard copy document or an electronic document depending on the circumstances. But the deed is the document that the seller signs, which transfers ownership from them to the buyer. Now, oftentimes, who's on title and who's on the deed are the same. You get the same answer to both questions, right? But often enough, there's different answers to that. You know, we can look up a deed in the public record and find that the house is owned by John Smith, according to the deed. But John Smith has passed away. So John Smith doesn't own anything because in this society, we don't allow dead people to own things. So the house, even though the deed says the house is owned by John Smith, who's on title to the property? The estate of John Smith, right? And there are many similar examples like that where you'll find a mismatch between who's on deed and who's on title. Oftentimes we'll see a property owned, when we look in the land records, the deed says the property is owned by Mary Smith, but the person selling the property is Mary Jones. And it turns out that Mary Smith got married and she's now Mary Jones. So the deed says Mary Smith, even though title to the property is Mary Jones, right? Because Mary Jones owns the property. So there's any number of situations where the deed and title can be mismatched. So it's important to understand the distinction. The deed is the document that transfers ownership, while title is who actually owns the property. So two distinct concepts there. Now, all deeds in the state of Maryland, and all states, as far as I know, are recorded in the public record. Why? Well, for the very simple reason that the county needs to know who to collect the taxes from. So ownership of real estate is public. And deeds can tell us a whole bunch of things that we can't find anywhere else, right? They'll obviously tell us when the last transfer of the property was, what the date was, what the sales price was on that transfer, and who bought it. But they can also tell us how the owners hold title, right? And let's talk about that a little bit. Because if you have one person that owns a house, the ownership is called sole ownership. Very simple. It means just one person owns it. It can also apply to a company. So sole ownership means one person or one company owns that property. There are, in total, 4 different forms of ownership. Sole ownership, which we just talked about, tenants in common, joint tenants, and tenants by the entirety. 2 of them are quite simple. Sole ownership is easy. That means the house is owned by one person or one company. Tenants by the entirety, also pretty easy. That means that the house is owned by a married couple. The other 2 are a little bit more interesting. Joint tenants and tenants in common. Now they have a couple of features. Joint tenants means that there's more than one owner of the property. They are equal partners in the ownership, and they enjoy rights of survivorship. So if person A and person B own a property as joint tenants, and person B passes away, person A becomes the sole owner of the property, instantly and automatically, right? Now contrast that with tenants in common. Tenants in common means more than one person or more than one company owns the property. They're not necessarily equal partners, and they don't enjoy rights of survivorship. Here's an easy way that you can think about this. Joint tenants, that's for intimate relations. Maybe intimate's not the right word, but close relations, family relations. These people that want to own the house together, if a brother and a sister buy a house together, they're probably going to be joint tenants, because if one of them passes away, the other one just takes ownership of the house. However, tenants in common, if you have 2 business partners that decide to invest in a property together, they can go in and say, all right, we're going to be 50-50 on this. We're going to split everything down the middle. Company A or investor A takes 50%, investor B takes 50%. If investor B passes away, investor A doesn't suddenly become the sole owner of the property. Instead, their ownership would pass to their estate, right? So the way you want to think about these is tenants in common is typically for investors or people that are at arm's length, while joint tenants is for people that are more closely related to each other, either through an intimate relationship. Oftentimes you find people that are engaged to be married, they'll use joint tenancy. Family members that are going in together will use joint tenancy, while tenants in common tends to be more for investors. Tenants in common also has another interesting feature. As opposed to joint tenants, if you have 2 people that own a house as joint tenants, they are by definition 50-50 partners. They can't split the ownership any other way. If you have 3 people that are joint tenants, they each own a third. 4 people as joint tenants, each own 25%. You see the pattern here, right? They have to be equal partners by definition. In order to be joint tenants, your ownership share has to be equal. Tenants in common don't have that requirement. So if you're going to be an investor, you can invest with a partner and split the ownership 50-50 and hold as tenants in common. Or you can decide to hold it 60-40, 70-30. I even once saw an incident where there was somebody that owned 99% of the property and their tenant in common owned 1%. So tenants in common is more flexible than joint tenancy, but it doesn't have the benefit of survivorship. So when you're talking about people buying a house together, it's important that they understand how they're going to hold title, because in the event one of them passes away, there'll be significant consequences if they're not holding it the correct way. Ebony, did you have a question? I thought I saw you raise your finger.
Yeah, you know what? I mean, there was somebody who wasn't able to join the call tonight, but I'm sure they're going to tune in and listen to this. And it was just a brief call, but the gist of it is that he is thinking about investing with 2 other folks. And just as you illustrated, it wouldn't be split equally. And he was asking if I, knew any real estate lawyers that could help them, and trying to figure. Yeah, and I said, as it were, join us tonight. But so I think that what you're talking about fits really well. You've talked about whenever someone passes away. What about whenever you go to sell it? Are there any implications then?
For the way you hold ownership, not particularly. Because when we sell, every one of the owners has to be in agreement, right? Everybody's got to sign the deed. Everybody's got to sign the contract. Everybody's got to agree to the sale price. And that doesn't change between joint tenancy and tenants in common. So from a sales point of view, no, there's really no difference in the process when it comes to joint tenants versus tenants in common. Good question.
What about whenever, the seller's take home? Let's say they, whenever they go to sell, if you were to settle the deal, would that just be a different mechanism or a different contract as far as how that would get split? Or would you be able to just do, they own, let's say 33, 33, 33, just for easy numbers.
Yeah.
Would that payout look like that, or would it be one lump sum? How would that go?
Great question. So the default setting is we're going to split the proceeds according to the owner's ownership. So if you've got 3 people that are tenants in common and they each own 1/3, they can each take 1/3 of the proceeds as a default setting. Now, important to note here that if the parties are in agreement, they can split the proceeds however they want. And we see that frequently enough with the example that jumps to mind is if you've got adult children that buy a house and then mom and dad co-sign the loan or take some ownership because they helped with the down payment, but really it's the kid's house. When the kids go to sell, mom and dad have to show up to sign the deed, but often enough, mom and dad will sign a piece of paper saying, yeah, they can take all the proceeds of the sale. We don't want it. And then we'll make the lump sum to the adult children rather than to the parents that co-signed. So very good question. The answer is the default setting is we split the proceeds according to the ownership. But if the owners all agree, they can split the proceeds however they like. Excellent question. Thank you for that. All right. Now, let me give you guys some resources. And there are 2 in particular that I find a lot of realtors are unaware of that you should be aware of. So I'm going to share my screen and share with you 2 websites that if you're not already aware of, you should be. And the first one is, can everybody see that? There it is, right?
Yes, I can see it.
Thank you. The first one is what is commonly referred to as SSTAT. This is the Maryland Department of Assessments and Taxation. This should be your first stop in any research that you're doing on any piece of real estate in Maryland, because all you need is the address and you can look up any property in the state and get a whole bunch of information on it. So I'm going to pull up the house that I'm speaking to you from. If I can move there it is, my Zoom thing out of the way. Okay, all you have to do is put in the county and then search by street address. And I am at 5701 Green Valley Place, which is my house. On this screen, you can find a whole bunch of information. Right off the bat, you've got the owner's names right there. John, which is my government name. I don't give it to a lot of people. Most people call me Jack, and my wife, Jennifer. You can see that this property is residential and that we use it as our primary residence. Confirming that, you've got the mailing address of the house matches the premises address of the house. If the mailing address were different, presumably that you could find that this would be an investment property. Down below, it gives you a whole bunch of information about the property, the square footage of the property, the square footage of the house itself, the square footage of the land, the transfers, the assessed value, the last time the property was transferred. And very interestingly, on the right-hand side here, it gives you the deed reference. The deed reference is what we call the liber and folio, the book and page number that you can find the most recent deed that was recorded on this property. And to do that, we're going to use another website. So the first one here is SStat, which is stat.bat.maryland.gov. And the second one I'm going to show you is this one, mdlandrec.net. Now on this one, you do need a username and password. They're free, but you have to sign up for them. So just give them your email address, create a password, and then you're good to go. Now, similar to SStat, we're going to do a search by county here. My house is in Howard County. And we're going to copy and paste the book and page number from SStat into LandRec. The book is 18046 and page is 96. So we paste it in here. You see the book, 18046, page number 96, and we hit go. When we hit go, we find the most recent deed to the house. I'm just going to download this page. No, you know what? I don't even need to do that. Right? We have the deed to the house. And the deed shows us who owns the house, the day it was transferred, January 6, 2018, Jennifer Lindsay Kennedy Carter and John Carter. It'll show you how we hold title. Let's see, down here in this paragraph, grantees in fee simple. And there's reference to us being husband and wife. So we are here it is, tenants by the entirety in the second paragraph. Conveys unto the grantees as tenants by the entirety. Tenants by the entirety meaning that we are married. And if you're married to a real estate attorney, here's what qualifies as a romantic gesture. Now, this house was bought in 2015 by Jennifer, who was a first-time homebuyer at the time. I was not, so we put the house in her name. Then we got married, and we added me to title on this quitclaim deed. And it says, on January 6, 2018, the grantor was the most beautiful bride in the history of Howard County, on which date she married John Carter in an elegant evening ceremony and is now and forever known as Jennifer Lindsay Kennedy Carter. And that is as romantic as a real estate lawyer can get. It is a matter of public record in the state of Maryland that my wife was the most beautiful bride in the history of Howard County. If anybody else would like me to write a deed for them to impress their wife, I'm happy to do that as well. But these two websites will be your go-to source. And the reason we need two of them is there's a caveat on SStat, which is this. If there's more than two owners of the property, you're only going to see the first two names here. Okay, so if you have 3 or 4 or more people that own a property, the only way to really find that is on LandRec by looking at the deed. The deed will tell you exactly who owns the property, how many of them there are, and how they hold title. So those two searches, SStat and LandRec, are crucial to understanding what the ownership of a property is and how to proceed. I'll add one other comment. I'm going to stop the sharing of the screen next. I just want to show you those two sites. Add one other comment about tenants by the entirety. There's really very little practical difference between tenants by the entirety and joint tenancy. The only real difference is this: protection from individual creditors. And let me explain what I mean by that. I'm an attorney. My wife is a physician's assistant. She works in the emergency room. Because of our careers, it's entirely possible that one of us gets sued through the course of our career for malpractice. If that happens, it's more likely to happen to me than my wife. If that were to happen, and I got sued for malpractice, and the person won a monetary judgment against me, that judgment ordinarily would attach to every piece of property that I own in the county. However, it would not attach to my house because I don't own my house. My wife and I own my house as a single unit, right? The house is not owned by me and her, it's owned by us. And the judgment is against me. so it doesn't attach to the house. In order for a judgment to attach to a house that's owned as tenants by the entirety, the judgment must be against both of the parties, right? The judgment must be against us, and if it's against us, then it can attach to our house. Otherwise, it would not attach, right? And there are a number of types. Yes, Ebony.
Question about that. If you owned the house and it was an LLC that owned the house, is that an extra layer of protection for you? Or, I mean, or is it only a trust could protect you?
Great question. The short answer is yes. The short answer to that is LLCs provide an additional layer of protection, which is a common tool that landlords use, right? Instead of owning the house in their individual name, if something were to happen, they would be liable and they could get sued. If they put the house into an LLC, then it's the LLC that is liable and could be sued rather than the owner themselves. Now, there's a big old asterisk on that, which is the LLC can't just be a shell company. It needs to actually be a company, a real company with, employees and bank accounts and all the things you think of as a company. Because if it is just a shell company that doesn't actually do anything, then the legal phrase here would be that the liability would be able to pierce the shield, right? The LLC is a shield to the individual, but if it's just a shell company, the liability can go through it. So, a lot of times I often get questions from investors that are relatively new that just own one property that want to put it into an LLC. And it's often not worth the time and expense of putting the property into an LLC if the LLC is simply for that one purpose. Now, if they own multiple properties and they're managing them in a professional way, and the LLC is collecting rents and it's handling customer complaints and that sort of thing, then absolutely put those properties into the LLC, and it'll provide some liability protection against the tenants.
Can you do a quit claim deed from a property that is, like, let's say, owned by tenants by the entirety, and you realized, oops, this should be actually in an LLC? Can you do it that way? Because I know that lending practices for, purchasing with a, let's say if I go and I want to try and purchase a home using my LLC, I'm going to be subject to different lending standards than if I go as a person. And so I think that a lot of people end up buying as their, regular self because of how stiff those standards are. But once you own the property, I don't know for how long, are you able to then do a quit claim deed and transfer it into an LLC?
Yes. Interesting question, and it raises a number of issues. The short answer is yes, absolutely. You can quit claim deed your property to anybody you want at any time, right? The questions that arise are you going to pay taxes on that quit claim deed? There are a number of exemptions for quit claim deeds. If you're transferring the property to a close family member, generally speaking, you don't need to pay taxes. If you're transferring the property from your individual name into an LLC, there is a tax exemption. There's a whole bunch of criteria that you need to meet in order to be exempt from the taxes. But yes, so the short answer is yes, you can definitely transfer the property. There's no waiting period. Once you buy the property, you can transfer it immediately into an LLC or anything else that you want. And the question is, will you have to pay taxes on that LLC? It depends on the circumstances, and in any individual case, talk to me about it and we'll figure out a way to, there's often a way to avoid the transfer taxes when you're moving a property via quit claim deed, although sometimes you're just on the hook for the transfer taxes. I would also say that while this is not at all my concern, you may be violating the terms of your mortgage if you do that, because the lender is likely going to, included in the mortgage, the lender is going to say that if there's any transfer of ownership, you need to let us know. Now, it happens every day that people transfer ownership, and frankly, as long as mortgage lenders receive their monthly payments every month, they never raise an issue about it, because they have the lien on the property and not on the individual. So the short answer is yes, but it may trigger taxes. It may create, it's unlikely to, but it is possible to create an issue with the mortgage lender as well. Great question. All right. Let's talk about and where I understand we've got about 5 minutes left. So I want to talk about one last issue that I think is very interesting, and then I'll open the floor for questions, which is life estate deeds. There are different types of deeds, and generally speaking, they do different things. We've mentioned quitclaim deeds already. Warranty deeds are generally what we use in a purchase transaction, but life estate deeds are really the interesting ones, because a life estate, when you write a life estate deed, you have the ability to designate who gets your property upon your death. And they come in two flavors, the more common of which is a life estate with full powers. And what you can do is write a deed, record it into the land records that says, I, Jack, own this house for the rest of my life. And as long as I'm alive, I can do whatever I want with it. I can put a mortgage on it, I can sell it, I can paint it purple, I can do whatever I want. But if I die, or when I die, if I haven't sold the house or put a mortgage on it or anything else, then it goes to Bob, right? And when I die, Bob instantly and automatically becomes the owner of the house. It doesn't have to go through probate. There's no paperwork. Boom, I die and he takes ownership. The other form of life estate is less common, but actually my next door neighbor has one on their house. This life estate says, I own the house for the rest of my life. As long as I'm alive, I get to live in it and nobody can do anything about that. However, I can no longer put a mortgage on it. I no longer can sell it. I no longer have the power to manage the house. I only have the right to live in it for the rest of my life. And when I pass away, Mary gets it, right? And this is used, generally speaking, with somebody who's elderly, who's transferring the management of their day-to-day affairs to their adult children or to somebody else. And that way they guaranteed themselves the right to stay in their home, the home that they have bought and purchased. They guaranteed their right to stay in it and given up the right to manage the property. So life estates are a very interesting way of estate planning, planning for your own demise, and they get used in a whole bunch of different circumstances. So yeah, there's life estate deeds in addition to quitclaim deeds and warranty deeds. And on that, we are running close to out of time, so I will stop. Although I'm happy to stay as long as you guys want and ask questions or talk about anything else that might come up.
So are there any questions on the floor? You can just unmute yourself and, just let us know. No questions out there? Okay.
I had a quick question. Thank you for this presentation. I understand things a lot further after your explanation on the types of ownership and the deeds. So my question is, if there is a mistake on a deed, do you fix those mistakes? And is there any type of insurance that goes with these types of transactions?
Interesting question. I suspect that there is a specific scenario that you want to talk to me about, which I'm happy to get into with you after the call, but I will answer the question generally first. Yes, if mistakes get made on deeds, I fix them. Lawyers are people and we're imperfect and we make mistakes on deeds. One type of deed that we find common enough in the land records is called a corrective deed, because it corrects some mistake that was written into a prior deed. As a matter of fact, I'm working on one right now that I made a mistake on and I need to update the land records for. So yes, mistakes get made. Generally speaking, the attorney that wrote the deed will go back and correct it when the mistake is brought to their attention. When it comes to insurance on the transactions, yes, at the top of the speech, I said there's two things that the title company does. We handle the money and we handle the documents. There's actually a third thing, which is we insure the transaction, right? Every mortgage company in the country requires that when you're buying a house, if you're taking a mortgage, you buy the mortgage company a title insurance policy that says the title to this property is good and you have insurance just in case it's not. In addition to that's called the lender's title insurance policy. In addition to the lender's title insurance policy, virtually everybody who buys a house that they're going to live in, and nearly all investors, buy what's called owner's title insurance. And owner's title insurance protects against losses from things like liens on the property, ownership interests that were not taken care of at settlement. If there's a dispute on the property boundaries, or if a structure of yours, say a shed or a detached garage or a fence, if it creeps onto your neighbor's lawn or your neighbor's creeps onto your property, the title insurance will step in to make sure that resolving those types of issues does not cost the homeowner or the mortgage company any money out of pocket. So yes, there are two types of insurances: lender's title insurance and owner's title insurance that are generally speaking issued simultaneous with the closing.
Okay, thank you. And I don't have a specific reason for that question. I'm just learning as much as I can from you.
That's a
You've
that's a
explained things.
wonderful question. Great.
Yep, thank you.
Thank you.
Well, that flew by. It's already 6:30. So Jack, this was awesome. I mean, of course, I know all of us, if we, kind of gave ourselves a minute, would have more questions. I know I already have more questions, but you and I can talk offline, and I know that there's a few people who may be giving you a call who weren't able to make it. So I appreciate you coming on to the roundtable. This was definitely a very, very informative.
Thank you, Sarah, for sharing those two links with the group. If anybody needs to reach me, my email is very simple: jack@thetitlecode.com, thetitleco.com. Feel free to reach out to me. I'd be happy to help with anything you've got. And thank you very much for the invitation. It was my pleasure to be here.
Thank you so much. All right, Jack. Well, hopefully, you'll be in the audience one of these next coming months, because we always try and make it useful for everyone. So thank you for joining us as a speaker tonight. And for all you who don't already know, come back next month, same link, same time. And we're gonna have more amazing information. Jack, you killed it. I am totally impressed by all the things you said and all the things you imparted on us. So thank you. And thanks everybody for joining us.
Thank you all. Take care.
Bye-bye.